All right, appearances.
Nate Carnes on behalf of the people.
I'm Jeff Harrison. I'm here with Mr. Burns. He's next to me at the table.
Thank you. Mr. Burns is currently in pre-trial custody. We are here today for a plea and sentence, apparently. And I've got a written pre-trial agreement and advice of rights. I'm going to let Mr. Carnes tell us what the terms of the pre-trial agreement are.
Your Honor, it's my understanding that the defendant will be pleading guilty to an added count of unlawful use as a first offender. So that is the 90-day misdemeanor variety, and people would be dismissing UDAA and a habitual.
That comports with my understanding as well.
All right, Mr. Burns, is that how you wish to resolve this case today, sir?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. Mr. Burns, looking back to July 17th through the 25th of last year, 2025, were you on probation or parole at that time?
No, Your Honor.
Were you on bond pending any felony charges at that time? Okay. You are currently charged on a felony information with a count. That count is unlawful driving away of a motor vehicle. That is a felony punishable by up to 5 years and or plus the Secretary of State would suspend your license. There is also a fourth habitual felony offender enhancement that could increase that maximum punishment from up to 5 years to up to life. However, I'm told today that you're going to enter a plea of guilty to an added count 2, which is a reduced version of unlawful use of a motor vehicle, and that is going to be a misdemeanor. And if you do plead to that, the felony and the enhancement will be dismissed. One moment. Now, specifically, that would be unlawful use, and that would be of a first offense for that type of offense. Therefore, the maximum punishment would be up to 90 days and or a fine of up to $500 plus costs. Is that what you understood, sir?
Yes, Your Honor.
So by entering that plea today, you'll not have a trial of any kind. Does that make sense?
Yes, Your Honor.
All right. So the first thing I'm going to go over, we covered that pre-trial agreement, and it's 2 pages, and I see it here, and I'm holding it up. Is that your signature on page 2?
Yes, Your Honor.
All right. Did you talk about this pre-trial agreement with Mr. Harrison?
Yes, Your Honor.
And did he explain all of your rights and all the evidence and things like that?
Yes, Your Honor.
And are you satisfied with his representation today?
Yes, Your Honor.
And do you believe so far going through with this agreement is going to be in your, or is in your best interest?
Yes, Your Honor.
All right. Now, by pleading guilty today, you're not going to have a trial of any kind. Does that make sense, sir?
Yes, Your Honor.
Now, I'm holding up this form that says advice of rights, and I'm showing it to you. And is that your signature there at the bottom?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And even more importantly, do you understand that if you plead guilty today, and I accept that plea, you will be waiving all these rights on this piece of paper?
Yes, Your Honor.
So again, you'll not have a trial of any kind. Now, as to sentencing, this is a misdemeanor, so the sentencing guidelines do not apply. But there's a presumption for misdemeanors that you would only receive fines and costs. The court, however, can find reasonable grounds for a period of confinement. So therefore, I'm going to guess based upon the criminal history here that you have, that might give you some period of confinement. Do you understand?
Yes, Your Honor.
All right. Now, has anyone made any promises to you as to exactly what I am going to do for sentencing?
No.
Have there been any other terms, agreements, promises, threats, duress, coercion, of force, or compel you to plead guilty that we haven't talked about today?
No, Your Honor.
Therefore, sir, are you entering the plea of your own free choice?
Yes, Your Honor.
So as to the added count 2, unlawful use of a motor vehicle as a first offense, how do you plead? Before I accept that plea, I need you to tell me what you did that makes you guilty of the offense. Now, looking back here at the date range of July 17th through July 25th of 2025, what happened? Whose vehicle did you take without permission?
I believe it was Jennifer's truck.
Okay, well, was this a 2007 Chevrolet Avalanche, which I know is a pickup truck?
Yes, Your Honor.
And you believed it belonged to who?
Jennifer.
What's
Right.
Jennifer?
She's my daughter's mother.
Okay, now do you know who an individual, Russell Allen Rondo is?
That's her current boyfriend.
Okay, so you took this vehicle, whether it belonged to Russell or Jennifer, without their permission, is that correct?
Yes, Your Honor.
And you used it for some period of time, is that correct?
Yes, Your Honor.
And again, when you did that, you did not have their permission, is that correct?
That's
Mr. Carnes, do you believe the defense provided a factual basis to support that plea?
Yes, Your Honor.
Mr. Harrison, do you agree?
I do, Your Honor.
Mr. Carnes, you aware of any other promises, threats, or inducements?
No, Your Honor.
How about you, Mr. Harrison?
I am likewise unaware.
And Mr. Carnes, have I done a great job with Mission Goal 6.302?
The best.
Thank you. Mr. Harrison?
I'm satisfied with the record, Your Honor.
Thank you very much. The court agrees, finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof. Therefore, the defendant is found guilty as added count 2, count 1, and the enhancement will be dismissed at the time of sentencing. Mr. Carnes, are we going to do sentencing today? But to do so, because it's a victim's rights case, do I have Mr. Rondo here?
I do not believe Mr. Rondo is here. I also show that he did not respond to our.
For the victim to sign up for victim's rights?
Yes, Your Honor, so we can proceed.
Any objection to that, Mr. Harrison?
No.
All right. How long has he been in pretrial custody? Looks like here, he got a PR bond. Right?
Yes, I believe there was a violation that returned him to jail on the 13th. Does that make
Alright.
sense?
Yep, that's what I see. So he's been in there for 46. 55 days. I think we can proceed to sentencing.
Yeah.
Thank you. Mr. Carnes?
Thank you, Your Honor. I do show the defendant has a history of property crimes. In 2004, there was an attempted larceny in a building. In 2007, there was a destruction of property. In light of that, Your Honor, I would ask the court to impose a sentence of 90 days jail with credit as appropriate. Thank you.
All right, thank you. Mr. Harrison?
Well, Your Honor, I want you to know a couple of things. First and foremost, as you can also see, it's likely that Todd has some issues with John Barleycorn as well that he's taken steps to address. Unfortunately for he and I, he is also facing charges in Roscommon County that will likely land him in prison surrounding another vehicle in the destroy. I don't know all the facts of it. Frankly, I don't know that it's germane to this discussion. I think he's been in jail. I thought it was 58 days. I'm willing to defer to the court's much superior math skills. I think that's plenty of time on the misdemeanor for which he is now stands convicted here. It would clean this matter up and it would simply allow him to proceed with whatever he's got to get done in the Roscommon case.
Mr. Burns, you have the right to make a statement if you so choose before I issue a sentence. Is there anything you wish to say at this time, sir?
I was just asked that I can get sent back to Roscommon today. Continue my holding over there. So,
All right.
thank you, Your Honor.
The court sentences the defendant as follows. Court court sentences the defendant to a $50 state minimum fee, $75 crime victims' right fund fee, a $150 court cost, finding that that's an appropriate amount for the processing of this case, plus a $150 attorney fee for the time spent by the defense counsel on the case. There's no DNA fee since it's a felony, it should already be available. The court will assess a $500, wait, sorry, I take that back, a $200 fine. There's no supervision fee, as there won't be any supervision, and the court sentences the defendant to a 60-day jail sentence with 56 days of credit. That's 1 day for the day that he had before he got the PR bond, plus 55 for the remaining days since he was apprehended. Plus, he'll get credit for a day once he gets to jail, but he's going to be let out today anyways, as long as he's earned all his good conduct time. The court again finds that this is a fair, reasonable portion of sentence and that there are reasonable grounds based upon the prior criminal history involving property crime. All right, anything else, Mr. Carnes?
No, Your Honor, thank you.
Mr. Harrison? We don't need to do advice of rights.
Well, that's correct. I
Misdemeanor.
forgot. I
It's
jumped the
okay.
gun.
Don't worry about it. Mr. Burns,
Thank you, Your Honor.
you're done. Thank you. All right, our next case this morning is
Mr. Fortier, who joins me at the table regarding both files.
Thank you. You may be seated. We're here today for a sentencing in these two files. There is a Killebrew agreement, of course, because we're dealing with a child support matter. One moment. Before the court this morning is Mr. Stephen Saladay. He has, by the way, reached another milestone of another decade passed in his life. But I'm not going to say what number it is. All right, let's take a look. I don't think I caught any corrections. Ms. Williams, how about you? The PSI.
No, Your Honor, it doesn't appear that we received the PSI or it's not in our file.
Well, let's take a look. Issued, or I'm sorry, at least received in my office a month ago on February 4th. And so each case has 3 counts to which the defendant has pled. He pled as charged. And in each case, there's a Killebrew agreement that the defendant would be placed on a delay of sentence. And then if during the delay, he pays the arrears down for the first file down to $4,000 and continues to make his payments of the court-ordered amounts, he could withdraw his plea.
I do have it. It
And
was
that's-
still, it wasn't uploaded into the file, but it was emailed to me. I have it. I apologize, Your Honor.
That's okay. He'll be able to withdraw his plea and add and plead down to a single count of attempted felony to fail to pay. If he repays it down to 0 while continuing to pay his monthly payments by the end of that delay, then he can plead to a disorderly person misdemeanor. Now, the agreement as to file 129 is exactly the same as file 130, other than the delay is if he pays his arrears down to 5,000 or less, then he can do the attempt failed to pay single account. All right, Mr. Hartel, how about you? Any amendments, corrections, or objections to make?
No, Your Honor, I reviewed it with my client and we have no changes.
So the real big question, I think, before we turn to the sentencing is, has he continued to make his monthly payments?
My knowledge, he has, Your Honor.
Sorry. Not a good day for me for some reason. So on one of the files, it's been sporadic, Your Honor. There was a payment in July and then one in March for the monthly charge amount of $211 actually, and then there was $789 to the arrears in January, and then 211 to the child support payment, and then $71 to the arrears. And that is in file 25-14129FH.
So let's do it this way. Why don't you tell me if the Attorney General's office wishes to continue with the sentencing pursuant to the pretrial agreement or not? That's the final question here anyways, before I continue.
Right. Yes, given the amount of the arrears, and he has, we'll continue with it. And then we would have the time to determine if he's still going to pay, or if he's not, then we can always ask the court to accelerate his sentence.
All right, thank you, Mr. Hartel. Does that make sense?
It does.
All right, so Mr. Fortier, I'm going to explain that last statement to you, that last bit of the discussion. For you to get the benefit of the deal, the requirement is that since the time of the plea and the acceptance, and throughout the period of the delay, which would be for the next 11 to 12 months, you have to continue to make your monthly payments as ordered by the court for child support. Now, in addition to that amount, you must then, during this period of delay, continue to make arrears. Pay those arrears in one file down to $4,000 and the other file down to $5,000. And then if you do that, meaning you pay all those payments from the date of sentencing and you pay on the arrears down to those amounts, then you have the right to have your case, your pleas to the 4 or 6 felonies pulled out, and then enter a plea to a single high court misdemeanor for each file of attempt failure to pay. You understand?
Yes.
All right. You have any questions about that?
No.
All right. So, Mr. Hartel, you didn't have any changes, did you?
No changes, Your Honor.
All right, let's go to the people. Ms. Williams, do you have anything to add for sentencing for allocutions, or do I just go ahead and proceed?
No changes, Your Honor. We would just ask that you adopt the recommendations contained within the pre-sentence investigation report today. Thank you.
Mr. Hartel, how about you?
We would also ask the court to adopt the recommendations, Your Honor.
All right, thank you. Mr. Fortier, I'm going to go along with him. Is there anything you wish to say? Doesn't matter, just means you couldn't screw it up, so, all right. So the court here sentences the defendant pursuant to the Killebrew agreement that the defendant is placed upon a 1-year period of delay for up to 1 year. That is pursuant to MCL 771.1 parenthetical 2. The court adopts the terms or conditions for that delay that are listed on CFJ 145 pages 3, 4, and 5 within the pre-sentence investigation report. Court will assess a 3-day jail sentence with 3 days of credit. All right, the court. Hold on. The court assesses 6 $68 state minimum fees, 1 $130 crime victims right fund fee, a $300 court cost, no fines, and a $300 attorney fee, and there's supervision fees of $30 a month or $60 a month if there is any electronic monitoring, which I don't think is going to be necessary here for Mr. Saladay. All right, so Mr. Fortier, I've given you some fines and costs. However, I'm sorry, and they're due within 56 days, or a 20% penalty is automatically added. But we can deal with whether or not I generally waive that 20% penalty during any period of probation. All right, so what happens here is next, when we come back in about a year, depending on how well you've done, you might get probation, and then you can make those payments. But what we really want to see you do is make these payments for the arrears and the continued monthly payments. Okay, that's my big focus here for you. Any questions of me today, sir? We don't need to go over any advice of rights since the sentence is not yet final, and you'll be back here in about a year. Now, keep in mind, one of the phrases the prosecutor mentioned was accelerate sentencing. So let's say you don't make a payment for April or May. Well, they have the right to come back to this court and say, Judge, you didn't do what you were supposed to, therefore, we aren't going to wait 12 months. We're only going to do it now. And they have the right to do so. That's just my way of explaining to you. Make sure you're making the payments. All right, that's the best thing to do. Any questions about things, you can check with Mr. Hartel. All right, anything further today, Ms. Williams?
Just can you go over the jail credit if there was any?
3 days credit.
Okay, great. Nothing further, Your Honor, from the people. Thank you.
Anything else, Mr. Saladay?
No, Your Honor.
Thank you. Mr. Hartel?
No, Your Honor.
All right, we'll
Yeah.
see you all. Oh,
There are two separate files, so we have to do $230 crime victim rights. Because they're
oh,
charged
yes,
separately.
yes, thank you.
And then are they-
And then the fines and costs, just split them up, 150 for
150
one
each.
file, 150 and so forth. Thank you very much for catching it. All right, folks, we are done with that case. We're adjourned, and that means we are done with this morning's stock collection. Only 10 minutes late, and we need to change the clock.